All right. Good morning, everyone. If you're here for data privacy fundamentals, you're in the right room. Otherwise, check with the registrar. For today, we're going to talk about learning objectives, how privacy is similar to, but is not the same as security. We'll talk about why privacy matters, do a quick overview, speed run through some regulations, do a scenario activity, and then talk about what privacy looks like in practice, and finally wrap up, and I'll share some resources. There are links and things that'll all be in the slideshow that'll be shared with you. So in academia, you always have to sort of start out with, who is this bozo and why should I listen to him? So I'm your bozo for today. My name is Ben Archer. I'm the privacy manager in the Enterprise Technology Cyber Risk team. I've been at ASU for coming up on 4 years now. And before that, I spent about 25 years at the Maricopa County Community College District in a variety of roles. It's one of the largest community college districts in the nation. I also have sort of the alphabet soup of initials after my name. I have an MBA from here at ASU, a project management professional, and a variety of privacy certifications. The Certified Information Privacy Professional for the US, Certified Information Privacy Technologist, and Fellow of Information Privacy, all from IAPP, which is a professional organization for privacy professionals. All of this to say, I know a thing or two about privacy, and I'm really excited to be able to share it with you today. So we're learning objectives for today. At the end of this 45-minute, 50-minute session, you will all be able to explain why privacy matters across ASU and distinguish it from information security, identify what sensitive and regulated data looks like in your day-to-day work, and choose the appropriate handling controls for it, describe at least 3, probably more, but at least 3 privacy laws and policies, and at least 1 obligation for each of them, probably more. And then implement privacy practices into your daily work. That's really the goal of what we're shooting for today. So, when I first talk about information privacy, everyone's like, oh, isn't that the same as cybersecurity? I'm in the cybersecurity core in enterprise technology. It really tends to get a little bit confusing. So privacy is really about the appropriate use of personal data. So that's 2 aspects, right? Appropriate use, using it the way that the data subjects expect you to, the way that we're legally allowed to. And it's only about personal data. It's about data about individuals. And we have controls that we use, things like purpose limitation, using data for the purpose for which it was collected, and consent management, so getting consent for the ways that we're going to use data that might not be what data subjects expect. And then on the information security side, it's really about preventing the bad guys from having access to data that they shouldn't have access to. So we have things like firewalls and patches and managing vulnerabilities and things like that, ways that we try to keep the bad guys out. So the way that I look at it, we also have some shared controls like encryption and access control that really apply in both worlds. But the way I look at it is that security is the lock on the door. Security keeps people out, whereas privacy is the curtain over the window. It lets you open and close depending on what's going on, what type of information you want to share and with whom you want to share it. So a lot of people are surprised to know privacy is not enshrined in any of our founding documents for the United States. It's not in the Declaration of Independence, it's not in the Constitution, it's not in the Bill of Rights. It's kind of hinted at in the Fourth Amendment, but not really explicitly defined. And so it was never really considered as a legal concept until the late 1800s. This fella, who's a judge, came from a blue-collar family and married the daughter of a senator. And suddenly he was part of high society, and his photo was getting put in, the newspaper and the society pages, and they were reporting about his family and the things that he was doing and stuff like that. And he really didn't like that because that wasn't the world that he was used to. So he felt this deep-seated abhorrence of the invasions of social privacy on the part of the press. And then in 1890, this guy, along with his law partner, Louis Brandeis, who was a future Supreme Court justice, wrote an article called "The Right to Privacy" in the Harvard Law Review. And this is really what people point to as this is the genesis of the idea of legal privacy in the United States. So now let's fast forward to today and what the world of privacy looks like. If you sign up for a Google account and you actually try to read the terms that you're agreeing to, It would take the average person 450 hours to read all of those terms, 9.3 times as long as War and Peace. And I have links for each of these, so if you're interested in knowing more, or just ask me, I am always happy to share privacy horror stories. Cars can listen to, record, and then sell whatever you happen to say while you're in them. Ford recently patented technology for an always-on microphone that tracks everything you say and everywhere you go, and then sells it. There's a data broker that leaked precise location. So everyone who has a cell phone that has a GPS, all of your location history from 12,000 mobile apps. That's not 12,000 users. That's 12,000 apps, each of which have tens of thousands, hundreds of thousands, millions of users. All of that location data and history was leaked and is now out on the dark web, and there's nothing you can do about it. Gene testing firm, not 23andMe, they have their own issues, but another gene testing firm got breached, and all of the individual's DNA information was breached, and the court said, okay, well, you have to refund the users what they paid for the DNA test. That doesn't really make you whole, right? If all of your genetic information is now out there forever, you can't reissue your DNA like you can reset a password. Automatic license plate cameras, one of my favorite topics for anyone who knows me. Many of them are misconfigured to just stream live to the internet for anyone to look at. And the ones that are configured correctly, anyone who paid for a license to that service, including police, homeowners associations, private detectives, your disgruntled ex-partner, can go and access that information and query your location history at will. We have 4 of these cameras on campus here. Let's see. Smart TVs and streaming boxes. So if you have a Roku or a Fire TV or something like that, not only does it track the things that it's presenting to you, it looks at what's on your screen, takes a picture of it twice a minute, so every 30 seconds, takes a picture of it and says, okay, I think I know what this is. I think you're casting from your phone and you're scrolling through Instagram, or you're playing your new Switch 2. It's going to recognize what's on your screen and send it back home to monetize in some way or other. The metapixel, who's heard of the metapixel? It's a 1 pixel by 1 pixel image that's transparent and invisible, and it's on about 75% of all of the world's websites, and it shares information back to Facebook and Meta at large. And it was found on tax prep websites. It was found on the FAFSA website. And so it was sending information from taxpayers or from students who are filling out the FAFSA back to Facebook in violation of federal law. The Department of Ed actually got sued for having the metapixel on their website. Has anyone heard of National Public Data? It was in the news about a year ago. They had a massive breach. Just about everyone in the US's social security numbers and other information was a part of it. 300 million SSNs. National Public Data was a company of one. It was one person who was the sole proprietor. He put the password for his database in plain text on his website. He was not a cybersecurity professional, obviously, but he had access to all of this data. Got breached, he got sued, he dissolved the company and walked away. No one got paid for having their information out there. You didn't get your 35-cent check of the data breach that you might have gotten for others. Siri and Google Assistants capture information, capture what's going on around them, even without the wake words. Apple recently settled a lawsuit for $95 million because they were collecting people's private conversations and recording them and transcribing them and using them for their own good. Privacy matters, y'all. So I want you to take a time. I'm not going to make you share this, but I want you to take 5 seconds and just think about a time, other than right now, when you felt concerned about your own personal data privacy. It's scary stuff, right? So we're going to talk a little bit about why privacy matters. And these are just some of the areas, but this is why I love talking about this. The issues of power and autonomy, because everything you do, every click, every drive you take, every time you move, every conversation you have, it gets logged. And companies and governments, friendly governments and non-friendly governments, access that data for pennies, and they use that information to profile us, to predict us, and to steer our choices. If anyone was familiar with Cambridge Analytica, the whole idea was getting information about people to try and change their political viewpoints. That's not right. There is real world harm from these too. It's not always to get a different kind of targeted advertising. Bad data raises insurance rates. It blocks access to things like housing and loans. It lands innocent people on watch lists. I shared an article yesterday about those automatic license plate cameras and a sheriff in Colorado who arrested someone accusing them of being a porch pirate when it turns out that they just happened to drive through the wrong neighborhood at the wrong time, and that's when a package got stolen. And they got arrested based on nothing but that. We talked about irreversible exposure. Things like DNA, things like your location history, things like your voice. You can't just reissue them after a breach. That data that's out there is out there forever, and it follows us for life. There's also invisible discrimination that happens. Targeted ads, surge pricing, algorithmic scoring, it invisibly sorts us by different aspects of our lives that we're not even aware of, by race, by health, by income, by political inclination, by trade union membership, by all kinds of things without our knowledge and consent. And it shapes the information that we're able to see online based on those algorithms. And finally, and what's most important for us here at ASU, is that because of all this, data subjects, our students, our faculty, our members of the public, they'll pull back from research, pull back from digital services, pull back from free expression because they understand that it's being tracked and they don't want that, so they're just not going to give their data in the first place. And that's why developing trust and showing that we'll respect individual agency is so important in developing that trust to get data that we can use for research, for benefiting the world. So that's the doom and gloom portion of today's event. Now let's talk about what laws are in place to protect privacy. So there are regional laws across the world. Everywhere that is red has some level of privacy regulation. The darker red, the more highly regulated it is. So most of the world is covered by some type of privacy regulation, and some of them have this concept of extraterritoriality, meaning that law applies even outside of the country where the law exists. So many of you have heard of GDPR. GDPR is a European law. It applies to the European Economic Area. We'll talk plenty about that in a couple minutes, but it also applies to businesses here in the US, and it also applies to ASU. So to the extent that ASU or other organizations do business in Europe, those business operations in Europe can be fined, et cetera, based on violating these extraterritorial laws. And as you can see, there's a bunch of them. We also have state laws to varying degrees. Every state is different. Green states are ones that currently have laws, the blue ones are ones that are working on them, and gray are ones that have tried and failed to pass laws. And there are also, since every state is different, every state law has different exemptions. So the first round of state privacy laws, most of you have heard of the California Privacy Law, CCPA. That first round of privacy laws had these broad exemptions. So for public sector organizations or nonprofit organizations, CCPA is an example, all nonprofits are exempted. So by and large, we don't have to worry about CCPA. And most of the privacy laws that came after were modeled after CCPA and had pretty much the same exemptions. We're starting to see a new generation of privacy laws come through that don't have those exemptions. So there are, and we'll talk in a little bit about some state laws that do in fact apply to ASU and what the obligations are. And then there's sector-specific laws. So everybody knows FERPA. Most of you probably know HIPAA, GLBA, the Gramm-Leach-Bliley Act. So FERPA obviously for education, HIPAA for healthcare, GLBA is a banking industry law. PCI DSS isn't actually a law, but it is a standard that was developed by the payment card industry. All of the banks that, and credit card companies say you have to follow this or you can't process credit cards. So there are a variety of sector-specific laws, and federally in the United States, all of our privacy laws are only sector-specific. We do not have a national comprehensive privacy law. So let's talk about some of these. Now, I know many of you have probably gone through FERPA training and stuff like that. Many of you probably have gone through some of the HIPAA training as well. So you probably know at least the broad strokes of this. So I'm going to focus on some of the highlights that I think are the most important to take away. For FERPA, the Family Educational Rights and Privacy Act, the two most common exceptions. So I'll back up and say pretty much every privacy law, in summary, states you can't share private information unless. So the two most common unlesses for FERPA are the directory information exception and school official exception. Who's heard of directory information? Pretty much everyone here, you've heard of directory information. It's not a problem, it's publicly available, et cetera. So let's talk about what those means. FERPA protects education. Education records are any record that is directly related to a student or learner. So anything that is directly related to a person that's on campus, pretty much, can be considered an education record. We added learners in about a year and a half, 2 years ago. There was some advice from OGC saying that for learning enterprise and all of the learning experiences we have that are not for credit, for degree type learning experiences, those folks are also covered by FERPA, and their data are also considered education records. So any of that stuff that's maintained by or on behalf of ASU in any format, any of that stuff is considered an education record. Now, the school official exception requires a legitimate educational purpose. You can access data if you're a school official, meaning you're acting on behalf of ASU and your normal job, job functions, or you're a vendor working on behalf of ASU and their normal job functions. So you have a legitimate educational purpose if these two things are met. If it's necessary for your employment tasks or responsibilities, that's number one. And number two, the one that we usually forget, is it's consistent with the purpose for which the record is maintained. So if we're maintaining records for one purpose, attendance in class so that we can determine what a student's grade is, and we start using it for another purpose, oh, well, we want to track, how many students are ditching so that we can, open a new restaurant off campus for them to go to. That's not consistent for the purpose for which it's maintained, so it's not a legitimate educational purpose. I argue this all the time when we're dealing with contracts with vendors because they want to use our data to improve their technology. Well, that's not consistent with the purpose for which the data are collected, so no, you can't do that. The directory information exception is the other, and that's things like name and address and email and things like that. Annually, we're required to list, here are the things that are considered directory information. It's on ASU's FERPA disclosure. We can only use the directory information exception if any student who's opted out of directory information disclosure is excluded from the data set. If we do not intentionally exclude those students, I'm an opt-out student. Every institution I've ever been in, I've always opted out of FERPA directory information disclosure. If my data shows up in directory information, I know that that school is violating FERPA, and I'm the type of person who will file a complaint. So we cannot use the directory information exception unless we've confirmed that anyone who's opted out, anyone who has the FERPA flag set, is excluded from the data set. We also have to consider indirect identifiers, class schedule, your dorm, your birth month, Canvas discussion board posts were a big one recently. Those can still identify a student. So just because it's not a direct identifier, just because we redacted their ASU right and their name and their ample ID, they're still identifiable based on some of this data, so we still have to treat that as an education record. So that, in broad strokes, is FERPA. HIPAA is the Health Insurance Portability and Accountability Act. There are two things I want to say about that. There's only one P in HIPAA. It's not like HIPPO, so HIPAA. And second, the word privacy is not in this regulation's name at all. It's really about health insurance. It's really about being able to port your medical records to another provider and having accountability to make sure that it's not being misused. So HIPAA governs PHI, protected health information. It is some identifying information coupled with some information about healthcare, diagnosis, healthcare treatment, or healthcare payment. So any of that information together with something that identifies an individual makes it PHI. And generally, again, you can only use it unless, generally PHI can only be used for healthcare, for insurance, for payment, or healthcare operations. There are limited exceptions, but they are tricky. ASU is a HIPAA hybrid entity, meaning we have 8 of our business units, including enterprise technology, so my unit, are covered entities, meaning HIPAA governs what we do. The other units are non-covered entities, meaning HIPAA doesn't apply, which means that the exact same data at ASU may or may not be PHI depending on who collects it. Now, if a covered entity collects PHI and then discloses it to a non-covered entity, it's still governed by HIPAA. That is really the only circumstance in which a non-covered entity has to wrangle with HIPAA. There are some tricky things like a limited data set and HIPAA de-identification safe harbor. If you redact these 18 identifiers, then it's not considered identifiable. But the 18th identifier, if you've read the list of HIPAA identifiers, the 18th is any other information that could reasonably identify an individual, which means any sort of indirect identifier. So it's still tricky. And HIPAA requires a minimum necessary standard. We should use, collect, and disclose only the least information necessary to complete the business purpose. So that's HIPAA. We will have time for questions, but if you have some in the middle, please feel free to shout them out, raise your hand, whatever. GLBA is the Gramm-Leach-Bliley Act. It was written for the banking industry. Now, ASU is not a bank, you might be surprised to note, but as it applies to student loans, we are operating as a financial institution under GLBA. So to the extent that ASU disperses student loans, we are considered a financial institution and GLBA applies to us. And it applies to non-public personal information, NPI. So any information that is not public, that is related to the provision of a financial instrument, meaning a student loan in our case. GLBA has 2 components. There's a safeguards rule that is really the information security side of things. It's very prescriptive. You must have a risk assessment. You must have encryption in transit and at rest. You must have multi-factor authentication. You must annually report to your governing board, in our case a board, your compliance with these requirements. And then there's a privacy rule. The privacy rule generally says that if you are following HIPAA safeguard or FERPA safeguards, then you're compliant with the GLBA privacy rule. That's a relief because we're all pretty comfortable with FERPA safeguards. One of the differences with GLBA is that non-public information may be kept only as long as necessary for the regulatory or audit needs and then must be securely destroyed. So most of these regulations, other than GDPR, don't have a specific retention requirement. You can keep data as long as you like. GLBA is one of those exceptions where it requires that we delete data. GDPR, you've probably heard about it. It's General Data Protection Regulation. It's based on the physical location of the data subject or of the data processing. So if it occurs in the EEA, the European Economic Area, which is the EU plus Iceland, Liechtenstein, and Norway, if it happens there or the data subject happens to be there, then GDPR applies. Which means if I, this afternoon, get on a plane and fly to Spain, as soon as my plane lands, I have GDPR rights to my data, anywhere it's been collected in the world. It applies to personal information, which means any information about an identified or identifiable natural person being a human being. Identifiable is tricky because if you anonymize your data, right, and you assign, my name is, now I'm ABC123, and somewhere there exists a spreadsheet that says ABC123 equals Ben Archer. I'm identifiable, and that data set is governed by GDPR. There are also additional safeguards required for special category data, also known as GDPR sensitive data, race, gender, ethnicity, sexual orientation, trade union membership, all kinds of things like that that are considered by Europe to be requiring special controls. And so there are additional safeguards required for all of that. For us, that's standard biodemo data, right? Gender, race, ethnicity, age, all of those things are standard information that we collect. Processing GDPR data requires a lawful basis, meaning one of these 7 things you must have to be able to process GDPR data. Either the data subject's consent, performance of a contract, having a legitimate interest in the processing, meaning, to do the business that we do, we must do this, having some legal obligation like a subpoena or a warrant, vital interests of the community, that was used a lot in COVID-19, and then performance of a public task. And this is the piece that most people know about GDPR. It also allows for data subject rights. So data subjects have the right to be informed about how their data is used. They have the right to access any data that's collected about them. They have the right to correct any data that is incorrect, the right to erasure or the right to be forgotten. So they have the right to ask for their data to be deleted. All of those requests ultimately end up with me. The right to restrict processing in specific circumstances, the right to portability, so you can port your data to somewhere else, the right to object to data processing, and the right to avoid automated decisions or profiling without a human in the loop. That's a broad strokes GDPR. Then there's PIPL. PIPL is basically GDPR for China. It's the Personal Information Protection Law. It is very similar to GDPR. It is also extraterritorial and applies when you're offering goods or services to people in China. It has a broader definition of sensitive data, which includes any type of personal financial information, and collecting sensitive data under PIPL requires a separate specific consent for that data for a specific use. And that consent applies to that data only for that specific use only. Transferring data across borders requires a security assessment and specific contractual terms. You have to have some lawful basis or consent, but legitimate interest, like I have to do this because that's the business I'm in, is not considered a legal basis under PIPL. And in GDPR, if you violate GDPR, you get a fine. Where PIPL, in addition to fines, they'll do things because the Chinese government controls most of what happens in China. They can do things like delist you from app stores and revoke your business license in China and have individual financial liability for whoever is in charge of personal information protection. Not me, by the way. So that's PIPL. And then we have state privacy laws. These are the 6 states, Colorado, Delaware, Maryland, Minnesota, New Jersey, and Oregon. I'm going to have those memorized eventually. But they apply by residency, which is really tricky, meaning we can have a Colorado resident come here to Tempe, Arizona, and sign up for classes in person at the registrar's office, and their data are protected by the Colorado Privacy Act until they are no longer a resident of Colorado. That makes things really tricky. GDPR, in Europe, they say privacy is a fundamental human right. GDPR is written in that way. These are written more like consumer protection laws. They are designed to protect the user or the data subject from misuse of their data for commercial purposes, primarily. So instead of exempting organizations like nonprofits or educational institutions, it exempts specific types of regulated data. So education records under FERPA, PHI under HIPAA, NPI under GLBA, human subjects research under the Common Rule, all of those data are exempted from these privacy laws. But we collect an awful lot of data that does not fall under those regulations. So Colorado, for example, the threshold is you have to have 100,000 data subjects who are Colorado residents to meet the criteria for this law to apply. We track web data on, I think it was 1.2 million Colorado users last year. So we collect a lot of data about a lot of people that these regulations apply to. It generally grants GDPR-style data subject rights, right to access, right to delete, right to correct, right to opt out of sale, and has obligations for the organization, in our case ASU. Data minimization, collect only the data you need, use only the data that is required for the purpose, and that's it. So it's really easy to do, select star when you're writing a SQL query. Don't do that. Collect only the data you need, select only the data you need, process only the data you need. And purpose limitation. When you collect data, it is for a specific purpose. The data may be used for that purpose and only that purpose. If you want to use data for another purpose, go and collect it again. Generally, as a rule of thumb, if we have unregulated sensitive data that is data about people that doesn't fall under FERPA or HIPAA or GLBA, or the rule, treat it as if these laws apply because they very likely will in at least some scenarios. Okay, I've got 20 minutes left, so I'm gonna start talking even faster. All of these regulations generally boil down to roughly the same requirements. I'll run through them very quickly. There's individual rights, so the data subject rights, and then organizational obligations. The right to access your data, the right to correct any data that's incorrect, the right to delete data, the right to have your data be portable, to move to another provider, the right to opt out of specific types of processing like personalized advertisement, et cetera, the right to opt in for sensitive data processing, meaning opt-in is not assumed, you have to affirmatively opt in if your sensitive data are being processed. Age-based opt-in, so even given all of that, if you're under a certain age, you're required to opt in, we can't assume that you've opted in. And the right to not be subject to fully automated decisions, at least when they have some sort of legal outcome. So we can have a fully automated decision about, do we want to send an email to this person or not? We cannot have a fully automated decision of, do we admit this person or not? Organizational obligations, we have to have some notice, and there are some transparency requirements. That's why we have our ASU privacy statements. We have to have legal basis for processing and track it. We have to have purpose limitation, collecting data for a purpose, using it only for that purpose, recollecting it if we need a different purpose. Data minimization, only collect the data you need, only keep it for as long as you need it. Security requirements, obviously, we've got to keep the data secure. Implementing privacy by design, so as we're doing something new, incorporating privacy into building that thing. Different requirements for sub-processors, so ASU's vendors, we have to have contractual obligations for them to make sure that they're using data appropriately. Obviously, we can't discriminate, but that's also enshrined in these laws. We have to keep some records about what data we have, where it is, how we're using it, what our legal basis is, et cetera. Conduct risk or impact assessments. Data breach notification, so if there's a data breach under GDPR, I think the notification period is 48 hours. We have to let the European regulators know. Register with authorities in many cases. Appoint a data protection officer in some cases, also not me. And then requirements for international data transfers. Those are by and large what all of these privacy laws pretty much require. If we do these things everywhere, then we're compliant with 98% of the privacy laws out there. So, try and make it easy for you with the data classifications. Who here knows ASU's data classifications? Couple hands, all right. There's public. There's no harm in sharing public data. Put it out on the website, shout it from the rooftops, go nuts, right? Public data is public. There's absolutely no harm in sharing it. Internal data is data that's not intended for outside ASU, but there's little harm in sharing. So the way I look at it is, this is data that is subject to public rights or public records requests. If someone says, I want to submit a public records request and I want all of Ben Archer's emails, they'll provide it. They'll redact names and sensitive information, but all that information will be provided. That's internal data. I wouldn't want all that data published on our website, but it is still available to the public. Sensitive data, there's harm if it's shared. Pretty much all data about people is considered sensitive, and all data that is regulated, FERPA, HIPAA, GLBA, GDPR, et cetera, is all sensitive. And then there's highly sensitive. This is life and death stuff, so anything to do with health and safety, things that we have strict legal obligations around, like HR investigations, things like that, and then really sensitive research, like stuff we do for the DoD. That stuff is highly sensitive. We don't have a lot of highly sensitive data. We have a ton of sensitive data, and most of the data that y'all work with on a day-to-day basis is probably sensitive. So now we're going to do a quick exercise. Is this data sensitive? So, is Social Security number sensitive? See a lot of nodding heads. Good. You might be surprised to know we've talked about a lot of privacy regulations. Social Security number is not specifically protected by any of those privacy regulations. So FERPA data has more protections on it than Social Security numbers. How about your student loan balance? Yes, I see a couple nodding heads. So that's governed by GLBA, right? We're talking about student loans. That's non-public information. What about your appointment date for a therapy session? Yeah, that's protected health information because it's a healthcare provider. It's protected health information because it's information about a person coupled with some information about healthcare treatment. What about a student's address that happens to be physically located in the European Union? Yes, okay, good. Now what about date of birth with no other PII, no other personally identifiable information? If I had y'all sign up to show your attendance and I just had you write down your date of birth, is that sensitive information? Kind of, maybe, but if it's not tied to anything else about an individual, it's not really strictly considered sensitive. What about just zip code? If you were signing in on your attendance sheet and you just wrote down your zip code and nothing else, is that sensitive? I'm going to wait here until I see heads nodding or shaking. So, okay, mostly no's. Okay, yeah, because there's lots of people in my zip code, right? That doesn't individually identify me, so it's not necessarily sensitive. What about just gender with no other PII? No's, okay. What about the combination of the three? Okay, I see a couple nodding heads. That I'm really happy to see that, because that combination, and this is in 2000, so this I'm sure is much higher now, but the combination of zip, date of birth, and gender can identify 87% of US adults with just those three pieces of information. So as we talk about indirect identifiers, those are the types of things, oh, you know, it's just zip code in this data set, and it's just date of birth in this data set, it's just gender in this data set, but once you merge those data sets, suddenly you can uniquely identify 87% of your data subjects. If you join indirect identifiers with regulated data, it's still PII, and now the whole data set is regulated by whichever of those regulations we just talked about. So if there's any regulated element, consider the whole data set to be sensitive. And I mentioned there isn't a specific regulation about Social Security numbers. What I don't want you to do is say, okay, well that means Social Security numbers aren't a big deal, I'll just leave them out lying on my desk. What I want you to do is that feeling you get of, oh, this is a Social Security number, this is really secret information. Treat all of the sensitive data that same way. If you're looking at somebody's educational record or somebody's personal health information, have that same feeling of, ooh, I don't want this to be shared. I wouldn't want someone else to share this about me. All right, let's run through a couple scenarios. Joe Student, who's a new undergrad at ASU, logs into the student portal to upload his immunization records and his documentation for a registered disability. They contain sensitive health information, including his vaccination history. Which regulations apply that we've talked about today? Margot doesn't get to answer. She's seen this before. FERPA? HIPAA? It is FERPA because, oh, I don't have the answer in there. It is FERPA because the admissions office is not a HIPAA-covered entity, and because HIPAA doesn't apply to the admissions office, even if they're collecting personal health information, it's not considered PHI under HIPAA. Okay, now an athletics trainer at ASU faxes Joe's completed sports physical with his medical clearance, his details, his personal health information to Joe's coach in preparation for the upcoming season. Which regulations apply here? Is Sun Devil Athletics a HIPAA-covered entity? I'll give you a hint, it's not. So which regulations do you think apply here? It's still FERPA. FERPA is the only regulation that governs this because, again, they're not a HIPAA-covered entity. Even though we're talking about healthcare information, we're talking about information coming straight from a healthcare provider. They're not a covered entity, and therefore, FERPA is what governs. Okay, now the housing office emails Joe a link to a voluntary health and wellness survey requesting information about his mental health, sleep habits, and substance use to help tailor campus support services. Which regulations apply here? Guesses? Yes, it's still FERPA. It's still FERPA because ASU Housing is not a covered entity, right? Now, Joe's gone abroad to Spain, and he enrolls in an ASU online course. And that involves accessing course materials and submitting assignments and engaging in virtual discussions from outside the United States. Which regulations apply here? GDPR and FERPA, right? Both of them, because the processing happening here is governed by FERPA and our local regulations, but since Joe happens to be in Spain, GDPR also applies to all of his data. Okay, so now Joe goes to ASU Health Services, which is a covered entity, and gets an invitation to complete a post-visit satisfaction survey. The message references the type of appointment he attended and includes a personalized survey link. Which regulations apply? Just HIPAA in this case, because HIPAA sort of trumps FERPA in that scenario. Since Health Services is a HIPAA-covered entity, all of that information, it's personally identifiable because he has an individualized link, and it has information about the nature of his visit, so it's healthcare information. So that's covered as PHI, and HIPAA would govern. Okay, now Joe is asking Career Services to email his transcripts to a prospective employer based in the EU as part of his application process. GDPR and FERPA, excellent. So it gets to be tricky, and running through these types of things will help identify, okay, I need to do this, but not do that. But generally, if you treat all data as super sensitive and follow all the things that we've talked about, you'll be fine. So now we've got 9 minutes left, good. We're going to talk about privacy in practice. This is from an art installation called Privacy Illustrated. They gave a bunch of kids markers and said, draw what you think privacy looks like. So I love going there. There are hundreds of different things, but this is what, some 12-year-old said, this is what privacy looks like to me. So here's what you can do to improve privacy at ASU. First, follow our IT standards. So we recently redesigned all of the IT standards to align with FERPA and GDPR and GLBA and HIPAA, et cetera. So if you follow the IT standards for data access and things like that, you'll sort of automatically be in compliance with whichever regulations apply. Share data only with authorization, and use ASU-approved storage and data transfer tools. We'll link to the tools at the end of the slide deck. And then if you're sharing data outside ASU, we are required to have contractual protections in place. We cannot share sensitive data outside of ASU without some sort of contract that says, thou shalt not do X, Y, Z, right? So all of these regulations that required contractual protections, that's why within ASU, we're bound by policy that requires us to do all the things that we're supposed to do. If we're sharing it outside ASU, we have to have contractual obligations that force that on our vendors. Minimize the data you collect, purge the data that you can. So work with the minimal necessary fields. Don't select all the fields in a table, just select the fields that you need. And then follow the retention schedules. They're published on ASU's website. They come from the Arizona State Department of Library, Archives, and Public Records. They say, for this type of record, you must keep it this long. This type of record, you must keep it that long, et cetera. So once the schedule is met, delete it or anonymize it. And then implement role-based access or least privileged, meaning not everyone gets access to data. It's based on why you're using the data, why you need access to the data, and you get the least access that you need to do the thing that you need to do. So only staff who truly need the data for a purpose that is relevant. Because remember, this is about the appropriate use of data. So just having access to the data doesn't mean you can use it for anything you want to. It also has to be for a purpose that aligns with the purpose for which the data were collected. When you're doing Google Docs and Google Sheets and things like that, it's really easy to say share with everyone and just email the link. It's easy, but it's not safe. That is not least privileged access. That is not role-based access. Share it with individuals for specific purposes, please. Here's another Privacy Illustrated. A sneaky man is bamboozled in his desire to see your secrets because of your impenetrable privacy practices. Use official ASU tools. We have a data classification tool that will walk you through questions and let you determine which data classification applies to your data and which regulations apply. We have a data selector tool that lets you know which enterprise tools we have available that are available to store that particular type of data. and especially for AI. There is a very, very, very limited list of AI tools that can process sensitive data at ASU, and the list of sensitive data which they can process is also very limited. Unregulated sensitive data and FERPA data only for only 4 systems: Enterprise ChatGPT EDU, Gemini, and the other one, what am I forgetting? Microsoft one. And then Zoom AI is also allowed to be used for that type of regulated data, but no HIPAA information, no GLBA information, et cetera, that is not approved for any AI system at ASU. Aggregate data when you can, but watch out for small cell sizes. So if you have, if you aggregate data, but there's only one student in this zip code with that major, suddenly that individual is perfectly uniquely identifiable. Collect only the data that you need. I set calendar reminders. So twice a year, on January 1st and July 1st, I have a reminder in my calendar to go through and purge everything that I can. I strongly recommend find the slow times of the year and set a reminder to go through and just get rid of whatever you can get rid of. And then reach out to the privacy team, which is me. We're here to help however you need. So anytime, please feel free to reach out. I will get to questions in a second. We've got 4 minutes left, but I want to share here are the resources: the data classification tool I mentioned, the storage selector tool, the VITRA is the IT risk assessment process. We have a list of vetted vendors for specific data types. The AI acceleration team manages the list of AI tools that are appropriate for different types of regulated data. And then you can always go to Get Protected. We have training there for information security, for FERPA, for HIPAA, et cetera. So with that, thank you all, and I am available. I'll stick around for questions. So, questions? Anyone? Yes? That's a great question. So does FERPA apply to prospective students and to alumni? So yes and no. Before the student is admitted and enrolled in classes, their data are not governed by FERPA. So if someone submits a request for information, they fill out an RFI online, that data is not governed by FERPA, they're not a student yet. So the official definition of a student is someone who's admitted and enrolled at the institution. Now, learners are kind of another story because they're not necessarily formally admitted and enrolled. They're engaging in learning activities that may not fall into that, but that's sort of a tricky LE thing. But by and large, before students are enrolled and admitted, FERPA doesn't apply. Now, on the other side, once they're alumni, FERPA doesn't apply to strictly alumni records. However, any information that was collected while they were a student or by virtue of them being a student is governed by FERPA. Does that make sense? So if we collect new information from them after they've already graduated, then that's not governed by FERPA. Great question. Others? Great, then you're all privacy experts. I love to hear it. If not, I will be sticking around afterwards before the next session. I'm in the next session anyway, so I'll be here if you have questions. Thank you again for sticking around. And feel free to reach out anytime on Slack, Barcher, or ben.archer@asu.edu. Reach out anytime you have any sort of privacy question. I'm always happy to help. Thanks again.